Hello everyone, welcome to this webinar on GDPR. I hope everyone can hear us clearly. This session on GDPR will be conducted by my partners Rohan, Neela and myself, Nivedita. If you have any questions, we'll have a question and answer session at the end of the presentation. So please feel free to send us your questions in the chat window. Just to set out the context for this webinar, we are going to look at the GDPR specifically in context of its implications on Indian companies and what are the compliance requirements for Indian companies in context of the GDPR itself. So before moving on to the specific aspects of the compliance requirements of GDPR, we are just going to talk briefly about what the GDPR is and why it is relevant for us to talk about it here. I'm not able to move this. Yeah. Okay, so essentially the GDPR or the General Data Protection Regulation is a set of rules that was adopted on April 14, 2016. And it was done with a view to govern how personal data of EU residents will be handled. Right? The GDPR will come into force from May 25th, 2018, which means it's going to be effective within a couple of weeks. And all organizations to whom the GDPR is applicable will need to be compliant with its provisions as on this date. Again, the GDPR essentially replaces the General Data Protection Directive that was in place in 1995. While the directive was just a set of guiding principles that the EU members had to follow with respect to data protection, what the GDPR does is it is a set of regulations which are binding on organizations to which it is applicable. So if we look at the GDPR, essentially the thrust of GDPR is to focus on the fundamental right of natural persons to the right of controlling their personal data. And that is how the GDPR has been structured generally, which is quite different from how data privacy is dealt with in the Indian context. And as we move on with the presentation, Rohan will deal with this difference between the Indian data protection regime and the GDPR in more detail. But what the GDPR essentially does is harmonize the data privacy laws across Europe, in the sense that all EU members will now be governed by this regulation. It also gives more control to EU residents in terms of how their data is used. And in that context, the GDPR has laid out certain rights that will be available inherently to EU residents with respect to their the data that is being processed by entities, right? And this includes right to information as regards how the data is being processed, right to require erasure of data, right to basically erase the data altogether from the systems, right? It also imposes additional obligations on establishments that are handling personal data, in the sense that GDPR makes them more accountable by requiring them to incorporate appropriate technical and organizational measures to meet the requirements of the GDPR and how personal data is handled. Now, what really is personal data, and in context of GDPR, and what are the things that we need to look at if we are talking about processing of personal data? Personal data is defined as any information that relates to or is capable of identifying a natural person, and that could mean any information relating to say name of a person, identification number, location data, any online identifier, or any specific aspects of the physical, psychological, genetic, mental, or cultural, social identity of such natural person. A subset of personal data is sensitive personal data, which is basically personal data that reveals any racial or ethnic origin, political opinions, religious and philosophical beliefs of the person, any trade union memberships, any genetic or biometric data, or any data relating to health or sex life or sexual orientation of the natural person. So as far as sensitive personal data is concerned, there is a higher level of regulation that has been put in place by the GDPR as opposed to just handling of personal data itself. And we will go into details of that a little bit later on. Now moving on to why, if GDPR is a EU regulation, why should we be concerned with it, right? And this is possibly one of the most important changes in the GDPR, in the data protection regime itself in the EU. What GDPR does is extend the territorial applicability of the law to not just establishments that are operating in the EU. It also extends to establishments that are operating outside EU but are providing services or goods in the EU, or any establishments that are monitoring behavior of data subjects in the EU. Now, the term establishment itself is very widely interpreted generally under EU laws. So it does not necessarily mean that for you to be established in the EU, you need to have a subsidiary or a branch office or a project office or any formal establishment like that. It could also mean that you have a salesperson located in the EU and the data protection regulations will still apply to you. So therefore, taking a conservative view of the term establishment, although it's not specifically defined under the GDPR, you will become liable to comply with the obligations under GDPR. Now, if you're handling data of EU residents, you can be categorized either as a controller of data or as a processor of data. A controller of data would mean an organization that collects personal data from individuals and also determines the purpose for which the data is collected and the manner in which the personal data will be used. So essentially, they are the decision-making bodies with respect to how data will be used. A processor, on the other hand, is merely an organization that acts on the instructions of the controller and does certain actions on behalf of the controller. So in that sense, they are one step lower than the controller. And in the next part of our presentation, we'll be dealing with specific obligations of controllers and processors and how you can identify whether you fall under any one of these buckets or both. Right now, before going into that, and another important point is that the penalties for non-compliance are very high under the GDPR. Not only are you liable to pay administrative fines ranging from 2 to 4% of the worldwide annual turnover, or 10 to 20 million euros, whichever is higher, for any non-compliance. You are also liable to compensate the person who has suffered damage due to the infringement or a data breach. So this is a very high penalty that has been imposed on entities that are handling personal data, and which is why it is important for us to know what is it that we need to be compliant with. In addition to this, member states are also given the leeway to impose additional penalties where there are breaches under GDPR. Now, in this context, we will, based on this context, we will look at how you can identify yourself as a controller or a processor, and what would be the rights and obligations of the entity who is either a controller or a processor or both.
Thanks, Nivedita. Right, so this is Neela taking over from a nice introduction to the GDPR laid out by Nivedita. Thanks, Nivedita. So what I'm going to do is I'm going to look at the concept of a processor and a controller under the GDPR. Because if you're a company and you're concerned that the GDPR applies to you and you want to know what is it that you have to be concerned about, the very first thing you need to figure out is what kind of entity are you, and thereafter you can determine the obligations that apply to you. So before I jump into that, because that's again quite technical, I've got a slide here that just sort of shows you the structure of the GDPR, right? And want to highlight a couple of things, right? So the very first paragraph of the preamble. So the GDPR, it's a fairly thick document. I have it in my hand. It's nearly about 100 articles, and the preamble itself is about 173 paragraphs, and that's literally, I think almost a third of this document which I have in my hand. But the very interesting sentence which it starts out with, right? It says, whereas the protection of natural persons in relation to the processing of personal data is a fundamental right. Okay, so it's acknowledging that natural persons have a fundamental right to the privacy of their personal data, right? And this theme that this fundamental right of natural persons should be protected is something that runs throughout the regulation. Interestingly, in the next paragraph, it goes on to point out that the other objective that it seeks to achieve is the creation of a economic union with economic and social progress and strengthening of the economics within the internal market. And then it goes on to say that the fundamental right of privacy needs to be balanced, right? So that you can achieve these economic objectives, but at what cost? So I think the kind of balancing that the GDPR is trying to do is a very interesting theme, and it will be interesting, especially in the context, because as I'm sure that all of you are aware, India yet does not have its own comprehensive data privacy statute, although it does have certain rules relating to data privacy. So as and when the Indian data protection legislation comes along, it will be interesting to see what kind of framing we will have, whether we put this fundamental right to privacy front and center, or the way in which this is going to be framed. So that was just a background remark which I wanted to make. Similarly, if you look at the chapter on what are the principles that govern the way in which the GDPR is required to work. So again, it lays out front and center that, listen, the processing that you do with the data that you collect, the collection should be very strongly grounded on consent, which Rohan will talk more about, so I won't mention that here. And also the processing that you do, you must do it in a transparent manner, and it must only be for lawful purposes. So some of these, the reason that I was stressing on these points is that these are the principles which one must keep in mind as one goes about the project of compliance, right? Otherwise, it's just a whole lot of, sort of highly technical information, and having this background makes it easier to sort of parse that information. And the data subject enjoys a range of rights which are specifically set out. These include the right to access, to accuracy of data, to have any inaccuracies rectified, the right to have a say in the way in which the data is processed, to object to certain activities, to object to being profiled, and also the right to request for erasure of data. So I have covered the main principles set out in the first few chapters. So let's jump straight into the concept of which is set out in chapter 4, which is basically who is a controller and who is a processor. So a controller of data is basic. So there's the definition is up there on the slide. You can have a look. But simply put, a controller is a body or a person who is determining the purpose and means of processing. right? So it's an entity which is collecting personal data, and it is the entity which decides why it needs to collect this data, what is it going to do with this data, and what are the means which it is going to use to process this data, right? So the key thing to keep in mind is that it is the controller who's in the first line of fire, right? Is because most of the compliance requirements under the GDPR are on the controller. And it needs to be able to demonstrate that it has taken adequate technical and organizational measures. And I will draw your attention again to this phrase, technical and organizational measures, because it is a phrase that recurs throughout the GDPR, and this is what organizations need to implement. And these measures have to be in place in order to ensure data protection in two ways: protection by design and protection by default. So this again is a sort of, it's a spirit that drives the GDPR. What it simply means is that the controller needs to ensure that the way in which it is collecting this data, its organizational and technical interfaces in which this data is collected, is designed in such a way that it collects only the amount of data that it actually needs to carry out its function, right? So it shouldn't be collating a whole lot of data which may not be required for the purpose at hand. And it also needs to ensure that the design of the system by default, it requires very minimal data to be covered, and also that the data subject who is giving sharing his or her data is asked for consent in a very precise and sort of a very forthright manner. So there are no hidden pitfalls. So privacy by design and privacy by default is something that the controller needs to keep in mind. And as we go forward, this is going to become of increasing importance because, as Nivedita mentioned, the implementation date is May the 25th. And organizations which have exposure to the EU, whether they're offering goods or services in the EU, irrespective of whether a payment is required or not. So Indian companies who are doing this, right, who are offering goods and services in the EU, or Indian companies who are monitoring the behavior of EU data subjects in the EU, these are entities for whom GDPR compliance becomes necessary, whether as a controller or as a processor. So if you determine that you are an entity which falls under this category of either offering goods and services or of monitoring the behavior of EU data subjects, you need to ensure that the system that you have in place, that could be your website, your applications, or other modes of business whereby you're collecting this data, you need to ensure that it is in compliance with having technical and organizational methods designed to protect data both by design and by default. So separately, there are certain other items that you need to keep in mind, that you may need to designate an EU representative. What happens in case there's a data breach? What is the procedure to be followed? Sometimes in certain special cases, you may also need to do an impact assessment. And in other cases, you may also need to appoint a data protection officer. So these are the other things to keep in mind. Moving to the next slide. So now we'll come to obligations on processors, right? So simply put, again, there's sort of a really long definition of processing, which again gives a lot of different kinds of items, but very simply put, from the moment any data enters your system to the moment you delete that data, including the act of deletion, anything that you're doing with that data is an act of processing, right? And if you are processing personal data on behalf of the controller, then you become a processor. So the absolutely key and crucial point to note here is that the GDPR compels controllers to only use the services of processors that are able to guarantee sufficient technical and organizational measures that comply with the GDPR so as to ensure the protection of the rights of data subjects. Therefore, the contract between the processor and the controller is by law required to cover a variety of items. So you need to ensure that the contract is dealing very specifically with what is the purpose for which this data is being collected. How long are you supposed to hold it? What exactly are you supposed to be doing with it? What kind of processing, right? Exactly what types of personal data are you collecting? If you only require an identification data, do you really need the biometric information of this person? If you don't need it, don't include it, don't collect it, right? Data minimization is the principle to keep in mind. What are the obligations, rights, and duties of both the parties? And very specifically, the fact that whatever processing the data processor is going to do is only as per the instructions of the controller. This is really key because the moment the processor starts doing something with the data which is not as per the instructions of the controller, then the processor becomes a controller himself or herself with all the attendant obligations. So this is something to be really careful about. Confidentiality obligations. So the processor needs to ensure that its own staff, personnel, employees are all bound by suitable confidentiality obligations. So would recommend that all companies to whom this applies, who may be a processor, do a review of their employment, consultancy, personnel contracts to make sure that this is covered. Put in place adequate security measures. Rohan will deal more with what security measures are. And circumstances in which the data is to be deleted and returned, and the manner in which you will assist the controller, assist in data breach resolution mechanisms, and so on. Importantly, if the processor is going to be engaging a subcontractor, the same has to be done with the controller's express consent, and the terms of the subcontract must be materially same as with the terms that I've just discussed. And even if your sub-processor ends up not complying or doing something which is not in keeping with the principles that we just discussed, the liability of the original processor does not go away. So this is again something that if you are a processor who is going to enter into sub-processing arrangements, you need to ensure that your contracts are quite robust and covering these items. It's also important to know that how do you demonstrate that you have providing a sufficient guarantee of compliance with the GDPR's terms in terms of the protection of rights of data subjects. So you can do it actually if you are certified by a relevant body or if you adopt an approved code of conduct. So this is something again that processors should think of doing, because this is an easy way to demonstrate to the controllers with whom you're going to enter into contracts that, hey, I'm GDPR certified, I'm ready to do business, let's go. Similarly, again, in the contracts that you're going to enter into, the authority under the GDPR has also come out with a few standard contractual clauses. So that's again something that could be considered. The processor also has certain record keeping obligations. It needs to ensure that it's keeping a record of the way in which it is dealing with the data of the data subjects and so on. So I would like to hand the floor over to Rohan, who is going to now talk about GDPR compliance obligations in the context also of the Indian data privacy regulations, as well as a step-by-step chart on how companies can assess their compliance with the GDPR.
Thank you, Neela. Just a second. All right. Good evening, everyone. I'm Rohan George, and I will be discussing, as Neela said earlier, an analysis of the GDPR in comparison with at least the most comprehensive aspects of the existing Indian data privacy regime. And I'll just briefly get into what the next steps are for compliance as we see it at least. Sort of a roadmap for compliance with the GDPR. The reason behind this comparative analysis is that at least if a lot of your companies might have been dealing with data at some point or the other in the course of your activities. So you probably have some idea about the broad Indian landscape and the level of regulation. I'm sure you've come across at different points. My main objective is to try and explain to you the difference in scale between the level of compliance under the GDPR and the level of compliance with existing law. So the most comprehensive law under the Indian regulatory scheme for the GDPR at present are the Information Technology Reasonable Security Practices and Procedures and Sensitive Personal Data or Information Rules 2011, which we'll refer to as the ITRS rules here for brevity. The ITRS rules are mandated under Section 43 of the IT Act 43A and talk generally about the detailed requirements for data security and compliance in India at present. There are certain context-specific legislations as well. I've listed illustratively the NBFC Account Aggregator Reserve Bank Directions 2016 and the Aadhaar Act. There are other provisions which contain context or sector-specific data protection or privacy requirements. But I'm going to focus on the ITRS rules because this is the best analogy we have with the GDPR at present. Okay. So moving on from there. Let's compare the ITRS rules with our existing regulatory regime. To start with, let's examine the difference in applicability of the ITRS rules versus the GDPR. The ITRS rules tend to focus this whole act of regulation on the body corporate. So all processing, all provisions are referred to in the context of the body corporate, which is understood to be an entity involved in commercial or professional activities. So straight away that actually excludes from the scope of its activity a large number of entities which are not involved in commercial or professional activities. A political party need not be a body corporate, for instance, neither may be a religious foundation, perhaps an educational trust may not be a body corporate. On the other hand, the GDPR does not provide any restrictions on the type of entity which is covered by the GDPR. It is focused on the act of processing of data itself. So that is a very important distinction because just by this minor distinction, the scope of the GDPR is widened considerably vis-a-vis the ITRS rules. The next point to compare would be the territorial applicability. I think Nivedita has gone into this in some detail already. So I'll just mention that as Nivedita pointed out, while the ITRS rules are applicable to a body corporate or person within India, the GDPR has a much broader scope of compliance and covers people who either have an establishment in the EU, which definition is extremely broad-based as far as EU law is concerned, or it can concern people, or it involves people who are either offering goods or services, whether paid or unpaid, to data subjects in the EU, or who are monitoring the behavior of EU persons in the EU. Note that there is some distinction as to whether this is limited to citizens of the EU or residents. As of right now, there is still some debate on that topic. So it's not as if this is necessarily focused on EU citizens. In fact, the GDPR never uses the word citizen in any part of its provisions. So that's something which we'll have to look into in more detail at a later point. Moving on from there, the subject matter which is covered by the ITRS rules also massively expands the scope. The ITRS rules does define personal information, and it does have a few provisions which are applicable to personal information. most importantly, the provisions relating to the privacy policy. But in general, the ITRS rules tend to focus more on the concept of sensitive personal information. So sensitive personal information is supposed to be information that relates to passwords, financial information, health information, sexual orientation, and biometric information. If been noticing from Neela's and Nivedita's presentation earlier, this broadly corresponds to what is referred to in the GDPR as special categories of information. And what's important to note is that the GDPR applies to any information relating to identified or identifiable natural persons, okay? And it's not just necessarily that the information requires 2 data points which allow you to identify the person. It should be just enough that it is possible to identify a person. So it doesn't mean that you need someone's address or you need someone's actual name and such like. If you have enough data points in order to identify that person using a basic algorithm, using some kind of system or the other, then you are collecting information about that person. That's one distinction. Secondly, it relates to all information. Thirdly, the so-called sensitive personal information, as we understand it under the ITRS rules, are now given a much higher status of protection as special categories of protection of information, and those are treated differently in the course of different obligations under the GDPR. All right, then let's move on from subject matter to the concept of the privacy policy itself, which is an obligation which is placed under the ITRS rules. The ITRS rules does have a provision which relates to privacy policy. It says that, and this is the provision by which most companies are following statutorily when they put up a privacy policy online on their websites and such like, whether consciously or unconsciously, most companies are abiding by this particular aspect of the ITRS rules when they're putting up a privacy policy. The privacy policy is supposed to be providing for clear, accessible statements of practices and policies. It's supposed to mention the type of sensitive personal information which is being collected. It's supposed to mention the purpose for collection, the circumstances under which that will be disclosed to other parties, and the fact that there are reasonable security practices being followed and what those are. Okay. The GDPR, on the other hand, does not cover the concept of privacy policy in any one provision. On the other hand, an entire chapter of the GDPR is devoted to transparency and its modalities. Okay, Chapter 3, Section 1, essentially. Various provisions in that chapter are applicable to the creation of a privacy policy. In specific, for example, Article 12 requires that you communicate. So any communication you make relating to the processing of your data must be made in a concise, transparent, intelligible, easily accessible form using clear and plain language in writing. So this is an interesting point to keep in mind regarding the GDPR, is that there are a number of guidelines which have been developed which expand on certain concepts in the GDPR. These are called the working party guidelines. They are under Article 29 of the EU directive, which preceded the GDPR actually. And this is a working party comprising the different member states, information security ICOs from the different member states, who have basically worked together in order to publish what they understand to be best practice or best use guidelines. So there is a WP29 guideline which focuses on consent, for example. And that guideline makes it very clear that the language in which you communicate to the data subject about the nature of whatever you are going to be doing, of your processing, has to be the kind of language which is accessible to a layperson and cannot merely be legal language. So it should be something which is actually comprehensible to. So in other words, there's a statutory basis here for plain language writing, plain language contract drafting. So that's something to keep in mind. It's not your existing privacy policy templates may not be able to cover this kind of a requirement. All right. So moving on from there, Article 13 of the GDPR mentions the broad scope of information to be provided. It's fairly detailed, very comprehensive. So I will not go into each and every one of the requirements because there are quite a few of them. I will mention that it's important to provide the details of the controller and representative. You have to mention the purposes for which you're processing the data. You have to mention the safeguards taken to make transfers to any other country or to any third party. And you have to mention there's an adequacy decision. You have to mention who the recipients of the data will be, if there is any end recipient of the data. There could be another processor, another person who you are going to pass on the data to. Maybe the controller is a financial institution in the UK, and they're going to pass on some of their data to a back-end business services company in India. They will have to at least cover some aspect of that in their privacy policy, and they'll have to be very specific about it. They can't just be as general as was earlier allowed. Their next points are that they should mention the period of storage. They should mention to the data subject their rights, which are the rights to request access, rectification, restriction, or erasure, the right to withdraw consent, the right to lodge complaints. So they should inform the data subject of their rights in the privacy policy itself. They should mention whether they are accessing the data you're providing by statute, by contract, or as a simple prerequisite for entering into the contract. Each of those makes their own difference from a distinction perspective. They also are required to inform the data subject whether they actually are compulsorily required to provide the specific data being asked for. So there are certain kinds of data which the data subject may not be obligated to provide if they want to perform the contract, in which case the privacy policy actually has to inform you, if you do not want to provide this data, you're not obligated to this particular type. Let's say you're asking for personal location data for a medical apps company. It may be relevant or it may not. If it's not directly relevant, you need to tell people that they can opt out of providing location data. That's something which is an example. So there are a group of other obligations there, and they're fairly detailed for dealing with the privacy policy. So there's even a category of information which needs to be provided when you are not the person collecting the data from the data subject. So the privacy policy itself has to mention what kind of information you need to put on it in the event that you're not collecting the data from the data subject, or maybe you're a processor of the data somebody else is collected for you. Okay, moving on from there, let's deal with the concept of consent, because this is an important distinction between the ITRS rules and the GDPR. While the ITRS rules addresses the concept of consent, it says consent is to be obtained in writing through any mode of electronic communication. If you read the ITRS rules with the clarification subsequently, the point is that as far as direct reference to consent is concerned, that's as far as the ITRS rules go. It doesn't there are various aspects of consent which are covered to some less or greater extent in one or two sentences. But this is the main distinction between the ITRS rules and the GDPR. Whatever concepts the ITRS rules tends to cover in one sentence or a paragraph, the GDPR seems to devote pages and pages of detail on the same concept. So the granularity with which the GDPR gets into the same concepts of compliance compared to the ITRS rules is what really sets the GDPR apart from the ITRS rules. So in the GDPR, for example, you've got about 4 provisions which are expressly devoted to consent, and even through the rest of the GDPR, you have got consent coming up as a regular prerequisite for various aspects of performance. So I won't get into all of that, but I will get into at least the 4 important provisions related to consent. So Article 6 says that processing of data is only lawful with consent, subject to certain circumstances. So the only circumstance on which data can be ordinarily processed is with consent. Article 7 lays down what are the conditions for obtaining this consent. And in terms of the conditions required for obtaining the consent, there are certain issues, like, for example, I'll give this as an example. There might be a situation involving granularity. Essentially, if you are seeking permission from a particular person to access their location information as well as their medical health information, in order to provide, let's say, a taxi service, just for instance. These you might be saying, I want both these things. You do not give the data subject the option to opt out of one without opting out of the other. So therefore, you are not providing granularity of consent or specificity. So you may be allowed to say, for example, that you can provide someone, you are allowed to say, you may opt out of location, but then you opt out of our service entirely. For medical data, we are only requiring this for analytical purposes. And if you wish to opt out completely, you're entitled to opt out. So the concept of consent needs to involve a few of those fundamental prerequisites to be entered, to be considered to be consent at all. Moving on from there, Article 8 talks about the consent of children for information society services. This is actually of great importance to any person who is providing an online service, because an information society service has a larger meaning and context in EU law. It generally refers to any kind of entity which is providing online services, any service normally provided for remuneration at a distance by means of electronic equipment for the processing, including digital compression and storage of data at the individual request of a recipient of the service. So this concept has been understood to mean most categories of online service providers or internet service providers. And it's important then to understand that in order to obtain a children's consent for this, you actually need to put in place consent systems which are understandable by children. So that is actually a requirement which is provided in the GDPR itself. So that's something to keep in mind when, again, devising privacy policies. The basic takeaway from that perspective is that privacy policies are going to be far more complex documents as far as, and a lot more thought is going to have to go into how they're developed, essentially. So then continuing onward from there, certain special categories of information equivalent to our SPI under the ITRS rules are expressly prohibited from being processed except under certain specific conditions, such as explicit consent of the data provider. So what that basically means is that the ITRS, the kind of data which we talked about earlier, which is, I'll just go back to that for a second, information related to financial information, health, sexual and orientation, biometric information, other such sensitive categories of information are per se, are at the outset, they are explicitly prohibited. The only way by which they can be processed is with the exception, the application of certain exceptions, the most relevant of which here is the concept of explicit consent. So those four obligations, these four articles tend to provide a lot of information regarding the consent requirements around the GDPR. In addition to that, of course, it's important to note that the moment a person withdraws their consent, they can activate Article 17, the right to erase all personal data, which is basically, this famous right to be forgotten. So the right to erasure can be activated by a person as soon as they withdraw their consent. And another interesting and worthwhile noting provision is that automated decision making or profiling is only allowed subject to the explicit consent of the data subject. So this concept of automated decision making or profiling is worth understanding, because it's a concept where essentially any kind of decision making which is made using a combination of your data and an algorithmic process is an automated decision making process, and it's specifically covered under the GDPR for this particular reason. So in that way, the GDPR actually covers to some extent AI applications of data as well. So it's worth looking at from that perspective. Sorry, just checking on how we are time wise.
15 minutes now.
Yeah?
15 minutes.
Okay. All right. So then let's move through the rest of the provisions a little more quickly. Comparison between the GDPR and the ITRS rules. Again, as far as officers and representatives are concerned, under the ITRS rules, I think many of you may have had a statutorily appointed grievance officer who was to basically be able to, whose details were on the company website and who had to address privacy-related grievances within a month. That was the basic obligation on the ITRS rules. Under the GDPR, you have two different kinds of obligations. If you are processing EU subject data or monitoring their behavior in the EU, then you have to appoint a representative in the EU, which is a fairly strict requirement. There is an exemption if you are occasionally processing, okay, but the implications of that are as of yet not clear. At this particular stage, if you are processing EU resident data or EU data subject data or monitoring the behavior in the EU, then you have to appoint a representative. And a data protection officer is something which has come up on a regular basis as far as people trying to understand whether they do need to appoint a data protection officer or not. The broad idea is that if there's a core activity of an entity which is processing operations which require regular and systematic monitoring on a large scale, or if the entity is anyway processing special categories of data, which we've already discussed earlier, they will have to appoint a DPO. So the provisions are very clear with regard to what the position of a DPO is. A DPO can either be an employee of the company or can also be a person who's been employed through contract, through independent contract. And a DPO has very specific tasks and functions to be performed in the role of the organization. You can't just appoint a figurehead DPO. They have to at least be shown to be involved in certain aspects of data transfer and data transmission. They have a role in the company which needs to be complied with in terms of the GDPR. Moving on from there, conditionalities regarding transfers to third parties. I'll very briefly get into this. The ITRS rules cover, okay, this is the most important thing I think I'd like to cover, and the rest of this we can get into at a later stage because we have a certain amount of time, and I'd also like to talk to you about compliance steps. So that's something we'll get into. Let's first talk about transfers to third parties. Under the ITRS rules, a body corporate is allowed to transfer sensitive personal information if the transferee ensures the same level of data protection as provided under the ITRS rules, and if it's necessary to perform the contract with the body corporate and the data provider. Under the data protection, under the GDPR, you have Chapter 5, which deals entirely with international transfers. And while it doesn't cover local transfers, I'm sure we understand that international transfers are fairly relevant in our context, and it's something worth discussing. Firstly, it's important to note that Article 44 says transfer outside the EU of personal data can only happen under conditions of Article 5. So these are the only situations in which these transfers are permitted. Firstly, they are only allowed if the country offers adequate protection. The alternate, and that has to be certified by the EU supervisory authority. What is adequate protection? The alternate is if you could provide for transfer use outside the scope of an adequate protection assessment, only if you have appropriate safeguards. So appropriate safeguards are a fairly well listed group of safeguards I won't get into in detail, but they include at least the importance of getting certification, the importance of having a code of conduct, and the importance of executing binding corporate rules. So I'm going to move on from here to get into the actual next steps. I hope I've given you some kind of a flavor for the kind of difference in compliance between the GDPR and the ITRS rules. Basically, my objective there was to give you an idea of the scale of compliance which is involved. So what I'll get into now is I'll just get into an analysis of what do you need to do in order to achieve GDPR compliance. As for what we've understood of the GDPR, the first thing you do need to understand, at least as an Indian company or a company which is outside of the European Union, ordinarily outside the European Union, is to determine your preliminary applicability. That means, do you have any kind of presence in the European Union? Do you have a sales representative? Do you have a small back office? Do you have a subsidiary? You know, you'll have to identify exactly what your preliminary applicability is under the GDPR first. The next step after that is to identify your data flows. First off, understand what type of data are you processing. Are you processing data which is in the normal course of personal data? Are you processing data which should be considered under a special category status? In which case, you'll have other thoughts you have to make, other decisions you'll have to make. The next point is to understand what are the purposes and means of processing, by which the idea is, are you the person who is deciding what to do with the data? Are you the person who is having a decision in how the data is processed, what the data is processed for, and such like? Or is that something which is being dictated to you? Or is it a little bit of both? Because a lot of situations involve a little bit of both. In the first scenario where you determine data flows yourself, you determine how data is processed, you determine who it goes to, you are the controller. In the second scenario where somebody is actually giving you that choice and someone is giving you that information, you are the processor. And as I said earlier, there are certain scenarios where it could be possible for both to happen, in the sense that you could be processing a significant amount of data on behalf of someone else, and you could have a relationship with that person where a certain amount of data is allowed to be utilized by you for your own purposes, your own analysis, your own analytics and such like. In which case you would be a controller in one situation and a processor in another. So you do need to understand your relationship with the data being processed. The next thing you need to understand is to record the sources of your data. And this is fairly self-explanatory. The objective seems fairly straightforward as well. You're trying to determine how much of your data comes in through the European Union, comes in from the European Union. If it is being sent in from a controller, I guess that's fairly straightforward. But if you are the controller and you're providing, let's say, for example, an online service which is open to all, you need to figure out how many of your IP addresses are coming in from the EU. So the basic idea is to identify the sources of the data and what percentage of them, how incidental is business from the European Union, what is the context in which it comes in. Those are things you need to figure out. The next thing you need to do is to review the purposes for which you're using the data. So understand whether you're using the data for the process of employment. Is your using of the data only fairly occasional, or is it in the course of business? So understand how consistently you are utilizing this data and what the context is. Is it regular business or is it employment? There are different applicabilities on the basis of this. So on the basis of this preliminary applicability, data flow analysis, and statutory compliance, so on the basis of the first two, you would then get into understanding your statutory compliances. Based on what you looked at earlier, you would be able to understand if you need to appoint a representative in the EU. Based on what you've done earlier, you need to understand if you need to register yourself with the Information Commission, ICO, with the Information Commission Officer in the EU. And based on what you've done earlier, you will also be able to figure out if you need to appoint a data protection officer. These are, at least as of May 25th, all of the obligations are going to be applicable as on May 25th. But these are fairly important obligations which revolve around direct statutory compliances, such as registration and appointments, which then you will probably need to prioritize this first, is what I'm saying. You then most likely move on to step 2. Step 2 of the analysis involves the review and creation of internal and data subject facing documents, by which I mean the kind of documents which govern your internal organization's operations, as well as the kind of documentation which governs your relationship with the data subject. Okay. Remember again, even if you're a processor, you have an obligation to communicate certain aspects of your work. All right. Remember that the first thing that you do is to create internal policies. You will have to see if you have a code of conduct. If you have a code of conduct, you might need to revise it to be compliant with GDPR. See if you have a data retention policy. Again, if you have that, you might need to revise it in compliance with the GDPR. Create a roadmap for compliance with the handling of employee data under the GDPR again. And in each of these contexts, don't forget, and also binding corporate rules. As a processor, you will need to figure out exactly how to establish your relationship with relation to those. So those are the 4 internal policies which you will need to put in place as far as compliance with GDPR is concerned. I think Neela has mentioned earlier, or maybe I have not, if I have not covered it, it's important to note that having in place a code of conduct, a data retention policy, having in place some kind of adequate certification, all are factors which go towards indicating that you have complied with sufficient technological and organizational steps to be compliant with GDPR. These are not hard and fast rules, unlike the ITRS rules, where it seems to be that the moment you have got the right certification, you can be compliant with the ITRS rules. Here, the certification and the code of conduct are indicators. They say that these may be relevant, but they are not prima facie determinations of compliance. But as far as factors towards compliance are concerned, I think it's very important to have those in place. So as I was saying, before I got ahead of myself, certification is the next step. You need to identify the right form of certification. It needs to be GDPR compliant certification. The supervisory authority and the commission will actually be setting up at some point an accreditation process to identify the kinds of certification which a company, which are considered to be compliant with the GDPR. Under the ITRS rules, ISO 27001 is already provided for as a standard of compliance. It is considered to be a fairly well accepted form of GDPR, a form of data compliance. It may be that this is something which is worth examining to see if it's GDPR compliant as well. The next thing you need to do is to create or revise your privacy policies to be GDPR compliant. I hope from what I've explained earlier, I've explained how much of a change will need to happen to the existing privacy policies of a lot of companies in order to achieve GDPR compliance. So that's a step which needs to be undertaken for sure. The next thing you need to do is, interestingly, because of the GDPR's privacy by design, data protection by design and default philosophy, you are going to have to amend your internal code of conduct as well as your software code. So that will require you somehow or the other creating some functionalities for privacy granularity in your application or website or service offering. You have to create some kind of privacy dashboard, or you'll have to create some kind of equivalent which allows people to deal with their data flows in a very different way than they've been dealing with recently. Until recently, you're going to have to allow people the option to actually revise, revise permissions, revoke permissions, grant permissions. All of that is going to have to be built into your application or software. So finally, the next step is involving third-party documentation. So the important thing to do is identify third-party relationships which involve the data. First, you identify whether you have a relationship with a controller or a sub-processor. Identify the relationship. Okay, so the next step after that is to create or renegotiate the relationship agreements to reflect their GDPR liabilities. By which, what I mean is that, as has been mentioned earlier, it's only possible for a controller to use a processor who provides sufficient guarantees to implement GDPR requirements. If a processor does not provide those sufficient guarantees, it's not even possible for the controller the GDPR does not permit them to do that. It's important then to look into the kind of compliance requirements that are required. Under Article 28 of the GDPR, there's a whole list of those, which I'll not get into in too much detail, but those will all be required to be renegotiated or revised or perhaps mutually redrafted in the relationship agreements that you have. And it's very important to consider how to allocate liabilities or indemnities. The GDPR specifically allows that any kind of compensation claimed by a data subject against a person can be claimed against another person who they believe was contributorily, in violation of the GDPR. So basically, controllers can claim indemnification from processors, and they can claim this amount, or they can claim damages from them for their failure to comply with GDPR. Finally, I think the last step is future proofing, which is basically putting in place a system to audit data procedures, creating access restrictions and modification systems for data subjects. More importantly, it involves a long-term kind of approach towards data protection. And as I said, privacy by design and default involves sensitizing employees on their new data privacy and data protection requirements, and sensitizing them for the GDPR, and providing training to personnel on how to respond to data breaches and other incidents. I didn't have time to get into this over here, but of course your obligations with regard to data breaches are much more intense under the GDPR. You have a 72-hour reporting requirement, which is actually the maximum amount of time which is supposed to be provided, no later than ordinarily, as opposed to the ITRS rules, which did not have a reporting requirement per se, at least under the ITRS rules. Okay, so with this, I hope I've given you some broad idea that there is a way to be compliant with the GDPR. It's possible. It's just it requires a systematic approach. And I think the other important thing to note is that the GDPR is considered to be the, well, I mean, at least based on the Justice Sri Krishna data protection white paper and such like, which has used a lot of language very similar to the GDPR's default terms. You might see the GDPR as some kind of inspiration or the other for a future data protection law in India. And from that perspective, if it might be a good idea to get an idea of how to comply with it at this stage, because it might actually be useful to understand the new data protection regime in India as well. So I'm done with my presentation. Thank you very much for your patience. Do we enable questions now? Yeah.
So maybe we can first take questions from the people in the room if there are any.
We should take from online first because they can't see you maybe.
That's all right. So we can repeat the questions. Yeah. Would you like to sit? Yeah. Nivedita?
Yeah. Okay, so we have a question on, is there a standard for anonymization and security standards provided by the GDPR?
So Shine, the way I understand what you want to know is that has there been any kind of actual certification standards set down, or the way I understand it is you want to know if the GDPR has addressed anonymization in any way and whether it's addressed security standards in any way. So with regard to anonymization, yes, the GDPR has at least referred to this concept of pseudonymization, basically. I'm not sure if I'm getting the pronunciation right. But essentially the idea is that, yes, part of the lawful processing of data involves putting in place systems for keeping the data secure, such as pseudonymization, as well as such as pseudonymization. There are a group of others, but that's something which is worth noting. So security standards, I'm assuming you're talking again about standards as in such as the ISO 27001. I've dealt with this earlier, I think. So the GDPR doesn't lay down any one standard of certification, but it lays down guidelines and it lays down a system by which those will be tested to determine if they are GDPR compliant. So there is thought given in the GDPR to these concepts.
The second question is related to can I retain the data despite receiving it? Oops.
Okay, sorry, it's just a right. So the question from Shine is, can I retain the data despite receiving a request for deletion, say to answer and respond to a future request from law enforcement? So there are exceptions under the GDPR for compliance with the laws of the the country, basically, in which it is being retained. So if there is a statutory requirement for you to retain the data, okay, for example, in India, there is actually for internet service providers a statutory requirement to retain data and IP data and access data for a certain period of time. So in that situation, you can and you probably have to retain the data, and you should not be liable under the GDPR because of the fact that you have to comply with your national country obligations first. But as long as you're only retaining it for the purpose of complying with these national obligations, that's going to be an analysis which is important. Yeah.
And also, just to add to that, I think also the record keeping obligations, could also mandate you to retain a lower level of data, right? For example, you'll retain data about the fact that there were this kind of information processed relating to these categories of subjects, right? So it may not be necessary in every case to retain all of the information that the request for deletion pertains to as well.
Yes.
So it would probably need to be examined on a case-to-case basis as to what was the request for deletion, what does it pertain to, and what does the law or record keeping mandate you to retain. So I think that's a very carefully, it would need to be analyzed as well.
Yeah, that's a good point. It will need to be looked at very carefully to see what exactly needs to be looking for.
Yeah. So next question we have, the question is that field executives sometimes take data out of office to perform a task. So how do you protect data in such cases? So interesting question, and I think it's a very practical question also that that people face. I think so. One of the things that I can think of, and this is something that we see, there are sort of very, if the data is being taken out on, say, a laptop or an electronic device, there are very sophisticated options available whereby you can secure such electronic device to really make it a black box in the hands of anybody except yourself. So that is one way. The second way also is if the data is not being taken out electronically and it's been taken out in other sorts of ways, the key thing is that your employees must be sensitized about their obligations to handle this data. So regular training of employees becomes extremely important, as Rohan was also mentioning earlier. And thirdly, you need to ensure that your employment contracts also contain an obligation of confidentiality, so on and so forth. If any of you would like to add.
No, I think that's right.
Okay. Next question is, for an Indian data company having its operations in the EU, does it need to have a data center in the EU as well, or can it be processed in a data center in India? So the GDPR specifically says that it is immaterial that the data processing has to happen in the union. All it says is that if you are processing the information of a European data subject, whether you are doing that in the EU or outside, the GDPR would apply. So I don't think that you need to read this as saying that you need to open a data center in the EU to process that data. Certainly the processing can happen outside, but the compliance requirements that we have outlined would continue to apply, because the way in which the law applies is that it is focused on the rights of the natural person. So anything you're doing that impacts the data of natural persons / EU data subjects, the GDPR would apply. However, that does not take away from the fact that you may, if the circumstances so warrant, need to designate an EU representative or designate a data protection officer, so on and so forth.
Just one point. With regard to your question, I think one thing which you should notice that an entire chapter of the GDPR is devoted to international transfers. Okay, so yes, I mean, if you are asking whether you can process data originating in the EU in a data center in India, that should be possible, but you have to keep in mind that any transfer of this data outside the EU has to happen under the circumstances of Chapter 5. So there are two circumstances broadly. One is adequate protection and assessment of adequate protection by the relevant statutory body, and that obviously hasn't happened yet. It will probably happen over the course of the implementation of the GDPR, and we'll have to see which countries are within and without the scope of this. At present, India is not in the list under the EU directive, if I remember correctly. But the other situation is where transfers are allowed with appropriate safeguards. So it's a very large and detailed list, what considers appropriate safeguards. But yes, it's possible to put in place with appropriate safeguards in order to achieve compliance. And depending on whether you're talking about processing within the same organization or processing within a different organization, this is going to change. But you have to keep in mind that there are going to be some serious restrictions, but it's not prohibited. These are just conditions under which they're supposed to happen.
The next question is the company GDPR compliant if it has very few EU citizens' personal data to process? So again, this is an extremely interesting question, and I think there are several angles to this. One is that the GDPR makes a specific reference to micro, small, and medium enterprises, and there are certain relaxations available there, which we can't go into detail here. Happy to take that offline. So that is one sort of angle to this. There are a couple more angles. If
I think generally speaking, the GDPR does not provide for any specific number of citizens whose data you should have been processing for it to apply. So assuming you are processing data for a limited number of people as well, GDPR regulation will apply to you, correct?
Yeah.
Yeah, so the only other scenarios is that if the processing is only occasional and it's not on a large scale, then certain other compliances may not apply to you, such as the requirement to designate representatives, officers, and so on and so forth. But we can't say that that our exposure is very small, therefore compliance may not apply. It would need to be examined carefully.
Basically what Neela and Nivedita said is correct. I think one thing to remember about GDPR compliance is it seems to apply on a spectrum. So you could be on the spectrum where you are liable as a processor under the GDPR, but maybe you don't have to appoint a representative at all. You could be requiring to be you could have a GDPR applicable to you to the extent that you have to appoint a representative. You could have the GDPR applicable to you to the extent that you have to appoint a data protection officer. Depending on the extent of your involvement with data and special categories of data, your applicability of the GDPR or compliance obligations of the GDPR are going to keep increasing. So I think even if you are processing only a few people's personal data, even there, it's important to understand that the people you're processing data for are customers or clients, or you're processing it on behalf of your customers. That's going to change the answer too. But prima facie, there is some amount of compliance which will need to be gone through. Yes. The next question is it necessary to obtain consent anew under the GDPR? That is it necessary to renew consent? If you're asking, yes, with relation to our existing privacy policy, whether you have to obtain consent anew, absolutely. The GDPR puts in place a completely new regime for obtaining consent and completely new standards for obtaining consent. Whatever consents you obtain prior to the GDPR, at least as far as they apply to EU data subjects, are not relevant anymore. So not only is it necessary to obtain consent, it's also necessary to completely reframe how you obtain consent. Yeah.
Next question is, how does email marketing get impacted based on the consent requirement? Should the current client database be contacted separately with GDPR consent mentioned? You take this?
Yeah, sure. So actually, about now a couple of months ago, no, Alan Kim? So a couple of months ago, we had a colleague from the UK who also spoke on the GDPR, and he gave us a very important example about their own law firm updates and the fact that those law firm updates under the GDPR at least require the firm to first send out a communication saying, can we please send you updates? Can we send you updates on this subject? Can we send you updates on that subject? How often would you like to receive the updates? An entire list, the law firm itself, in order to be GDPR compliant and to send out the updates, had to ask people if they would like to opt in. So email marketing is going to be impacted on the basis of the consent requirement. And I don't know what that means by the current client database being contacted separately with the GDPR consent. I don't know who the current client database is. So, but at least I think as far as your first question is concerned, absolutely email marketing will be impacted.
Yeah. So please email us if you want to discuss this, and then we can take
Yeah, then we have your consent.
So, the next question is, if an EU resident accesses an Indian website and the website tracks the user and stores its data, then would such access and storage be considered an international transfer of data? So a very interesting question. In fact, this squarely falls within the ambit of the question that are you an entity which is offering goods and services to EU residents or not? Okay. And in fact, some guidance is given in the preamble of the GDPR also, where it sets out a few factors by which the determination of whether a company is offering goods and services to EU citizens or not can be made. One of the ways in which the determination is made is, for example, if you're selling something, does the currency options on your website, does it also have a euro option, for example, right? So that is the primary question. And if you are offering goods or services, whether for payment or not, or if you are collecting data that monitors the behavior of EU data subjects, then yes, the GDPR would apply. I think it's less a question of international transfer of data and more a question of the GDPR application itself. If Rohan and Nivedita want to add anything on the international transfer of data point? Or?
So I think the provisions on the GDPR which specifically address the international transfer of data are focused on the conscious transfer of data by controller to processor or processor to sub-processor. They are not directly focused on the transfer of data by access to the data. So technically speaking, an EU resident accessing a website and the website tracking and storing the data is not transfer, it's more like collection, right? So to my understanding, the provisions on Chapter 5 relate specifically to transfer. There is a conscious active transfer data between collector and processor or between processor and sub-processor. That's the only thing I want to add on.
Yep. In case of an agreement having the governing law of an EU country, does the EU GDPR automatically apply? So it's quite a broad question. So I think it really depends on, are you collecting the data of EU subjects? Are you a controller? Are you a processor? So I think that's the way in which the analysis would have to be done in order to determine this.
Yeah, so in addition to that, if you are collecting or processing data of EU data subjects, then definitely GDPR will apply regardless of the governing law of the contract. Secondly, if it is the governing law is of a EU country, then you may also have to look at the specific regulations of that country with respect to data protection in addition to GDPR, because under the GDPR, EU members have the ability to put in place more legislations with respect to data protection itself.
Next question is that GDPR compliance will take 6 months in my company, but the effective date is too short. How do we handle this? I would say that identify the critical steps and at least try to ensure that you're compliant with that, and try to fast track.
Yeah, I think you need to identify in the first place what GDPR compliance will be required, and then unless you've already done that analysis, I think based on that you'll be able to see how fast you can put these processes in place. So I think as a starting point, you can look at what is it that you may need to comply with.
Okay, let's look at a scenario. Person A is a citizen of a country which is not in the EU, but the person is an EU resident. The country of nationality wants to maintain a database of all their citizens living abroad. This person A's record happens to be with the nationality country. So does the GDPR apply to this person's data as well for the various, for privacy policy, consent, data sharing, and data deletions? So I think that the GDPR also expressly mentions the manner in which public agencies, government bodies also can hold information. And also, since the GDPR applies importantly on the basis of residence and not on the basis of citizenship, there may be an implication here that the GDPR would apply, but because it's a very specific question, we can take this discussion offline. Want to add anything more?
I just want to visit the scenario again. Just
Okay, let's take it offline.
we'll look at it offline. That's fine. It's very interesting actually. But basically, other countries, let's say for example, you have a country which is collecting a certain amount of data from EU residents who happen to be Indian diaspora.
No, so in that case, it would be India.
Yeah, that's right.
India collecting
that's
details
right.
of.
So I mean, like, it is possible for the GDPR to be applicable to them, and technically speaking, as a public body, a public authority, they are also required to set up a DPO. But we'll have to look at this in much more detail in order to answer specifically.
Okay, would GDPR impact advertisement tech companies who are targeting mobile ads through different ad exchanges? So again, it boils down to, are you collecting the data of EU subjects? Are you a controller? Are you a processor? You'll have to do this analysis the way we described, and then you'll be able to determine this. Next question is, how does holding publicly available information affect GDPR compliance?
So, in answer, there are exceptions specifically provided regarding information which the data subject has made public or which has been in the public domain for some time. But information which has just happened to be made public because it's been disclosed or which has been disclosed through a breach is definitely not in the scope. So there are provisions which relate to this, the holding of publicly available information in GDPR.
Okay. Next question is, will the penalty be as severe as what is prescribed under the GDPR, even if the data breach is as minimal as one EU national? So I think that the authority is given certain guidelines and certain factors that it will take into consideration while determining the quantum of the penalty. And some of them also include, are you able to demonstrate that you were generally compliant, right? And if there was a question of a breach, etc., did you voluntarily go and disclose it? Did you take steps? Did you act in good faith? So there are a lot of factors like that that go into making that determination. So the moral of that story is try to be as compliant as you possibly can.
So just to add to that, the penalties that have been prescribed relate to the nature of the breach itself and not whether it's a breach under one EU national jurisdiction or not. So if it's a minor breach where you have not complied with certain processes that are not absolutely relevant, then the penalty will be lower. But if there are major security breaches, then the penalties will be higher. So essentially it depends on the nature of the breach itself.
Okay, so Suma, we'll get back to you on your query.
I see you have a follow-up clarification. So, if you would like to email us, we'd be happy to, provide have a more detailed conversation on this. I understand it's an issue which you'd like to discuss. Yeah.
How do private notes fit into GDPR? So, not sure, the question isn't very clear, but there is, the GDPR expressly provides that personal use and usage for household purposes, etc., which are entirely private uses in nature, those are not covered under the GDPR. Hope that helps. Okay, so we've come to the end of the questions on the webinar, and happy to take questions from the attendees in person if there are any.
So thanks for the primer. So I spent some time, a few years maybe in this area, because maybe 5-6 countries track them closely. I'm also certified on 27. So the question, and so I have live cases, live customers asking same questions. So the question I have for you is, the issue is a little more complex than nation A trying to serve nation B. So let's take an example of a hotel or an airline in Gulf, an Pacific Gulf. Their policies apply for the citizens, not for residents, which is 9%. So for most purposes, it is not there. Now, a hotel or an airline or a bank will have users or customers in various parts of the world, including EU. Given the fact that most of the Gulf operations are done technically from outside, you have many partners, either in the US or in Europe or in India or Australia, somewhere. Yeah. And all of them work on this cloud model, right? In addition to that, you have free zones, like economic free zones. Now, which law is applicable? So because the GDPR, I mean, 90% of it is mostly, they focus on person, right, privacy, transparency. Whereas IT security is about data, network, cloud, retiring model, archival models. So if you put it together, what is applicable for someone who is processing on the cloud behind that client in a pseudonymized data, which is split between, say, 2 nations? In fact, the other question is a little more complex than GDPR actually does entail the difference between data residency and data processing. Because in cloud, the processor moves to the data, not the data. So by default, I would assume that you shall stay in EU cloud for that, but my processing function can be somewhere. Because in most sectors, in India, they're forcing everybody to stay the data in the cloud here. You will be an Amazon, but you have to be in India.
Right.
It's like the old telco data, right? So I'm assuming that most data residency will be in the national area, which is not a problem for many people. That's changing the, we just change sign, right? That's not a problem. What is the problem is when you process in the data pipeline, the front end with the consumer or user is the client, which is maybe in Gulf or Australia, but the users or the customers are in European Union. Who is liable for what? The problem with the GDPR is that it is a binary classifier. It says you are a processor or controller, in some cases many. Most people will be more, because you may pick one field which I give, one field my location provider, my mobile gives, another field which my merchant ID gives, another field which I get from some social review, and you do a mashup, right?
And you do your analytics on the basis of
and you give it to somebody who in turn pitches to the EU, maybe with explicit consent. Who was supposed to do what now?
It's a good question. No, I think what you highlighted, I mean, for the benefit of, I'm not sure how much of the audio picked up your question.
The audio is very good.
Okay, great.
Except that it's directional mic the other way.
But I'll just summarize. I think basically you're raising a scenario as much as like asking questions.
Because this is 90% of the scenario for many of us.
I understand. And it's very important. I see what you're saying, because data flows are not necessarily focused in one jurisdiction or one or two countries. They can go all over the place. But I think there are two aspects of the GDPR. I would not say they simplify this, but I would say that they make the analysis a little more straightforward. One is that the GDPR focuses only on the action of processing. Okay, number one. So the data has to be processed in some form for the GDPR to activate, so to speak. When processing can involve even this, what you call accessing a database. So it's not as a processing.
So the problem is in IT terminology, and hence the related legal terminology.
Right.
You have processed data when you change the state of data.
Correct.
If I simply buy ESPN sports data on Virat Kohli and keep it in my house, I haven't processed it. I collected it.
But collection is also processing.
So they have a slightly different view. In data pipeline, when I change the state of data, I have processed.
Right. I understand. So
all the 20,000 will all be in that process.
No, I understand. So there's a difference in the word processing is understood from a technical perspective and from a legal perspective. But from the legal perspective, let's understand processing. Basically looking at the data is essentially processing the data in some form or the other. That is, if you are sitting on your system and you're viewing it, that is processing. So it's like,
So therefore the confusion is for any enterprise, large, big, small, whatever. What's the starting point? Do they seek a lawyer? Do they seek an IT flow expert? Whom are you supposed to call?
That's a very good point.
Whom are you supposed to call?
So we've done a note on this. Good.
Call Rohan. No, but I think what we've been reading on the GDPR, worldwide, everybody is coming to the conclusion that engineers will need to work very closely with lawyers going forward in order to ensure that there is compliance.
There's no other
way.
way.
My guess is that we are certified on 100,001. So we assume at the moment that they will revise the 27,001 to cover the GDPR requirement to some extent, as long as it is in that scope. They cannot go and put privacy policies and others, but they will assume at least for the data pipeline, they might augment a few things at a fine-grained level. But I would assume that you still need a national jurisdiction on the policy on what privacy is all about when you define. And when I do a cross-border, what is my liability?
Right. But here's the one, this is the thing which I want to just get back to on your particular scenario. You feel that there will be somewhat of confusion because data is crossing different jurisdictions and covering some people who might be citizens of one country but residents of the EU. But my understanding of this, at least at this particular stage, is that the GDPR does not concern itself whether the residents of the EU are citizens of somewhere else or not. If they are residents as far as I understand it. Their what that means is any kind of processing in violation of the GDPR of an EU resident's data is potentially subject to GDPR.
But imagine, but if I walk behind a firewall, which is the case with most people.
Sure.
Can I just assume that let my client, my customer take care of it? When they change the policy on their suppliers, we will comply. Is that a fair assumption?
So that depends on what your position is. So you,
for most people, suppose I am a vendor to a client who is dealing with you.
Right.
I'm not dealing with them directly.
You're not.
I only do some part what he says. So in your
so you're the processor. Yeah.
So shall I just wait for the controller to tell me, henceforth my identity policy is like this. This is my privacy policy. Now you shall comply. And then we will comply.
So that it would be comfortable if your liability were not directly to the if your liability is not direct
consumer facing or citizen facing.
But so
again, you'd be a sub-processor then.
Yes.
Yeah.
See, this is the case in all B2B scenarios. Yeah. In a B2C, it is quite clear because I am facing the.
Sure.
So very interestingly, I think the GDPR does not talk expressly about the liability of sub-processors, right? So in fact, it says the other way. It says the primary liability is the controller. He'll make sure that the liabilities flow down in the contract. Even then, the processor is only liable insofar as the processing obligations of the GDPR are concerned. And thirdly, that in case he engages a sub-processor, the main processor is still liable for the acts of the sub-processor, right? So in that, to that extent, you are safeguarded. But
so unless I have a sub-processor myself,
exactly,
But let us take banks, right? The campaign person, right? Most campaigns for banks are not run by them; they are run by someone else, right? Is the partner supposed to worry about this, or the bank will worry about?
So that's what I believe, that there are certain obligations the partner needs to worry about as much as the bank. So I believe that your obligations under the GDPR as a processor, some of them are to the controller, some of them are to the statutory authority under the GDPR itself. So there is, as Neela has clearly identified, there are obligations which the processor directly has. So in situations where they process outside of the policy set down, or process without following the guidelines of the GDPR, or actually use some discretion in processing, they can be directly in violation of the GDPR. And they can be then, basically directly facing
currently many people, at least people I know, hold the view in a B2B scenario. If you are ISO 27001 certified, we already have most of the processes when it comes to what we call data in motion, data at rest, data in process.
Okay.
Right? Okay. That's what that covers. It doesn't really cover the granularity of privacy and consent.
Sure.
Right?
Sure.
Because that is coming, the data is coming from them, right? We don't do that.
Yeah.
So the assumption is, we just wait for our customer to get back to us, because most posts are covered. If there's anything extra, let them tell us.
Right.
Is it a fair position to take?
So
or is there an audit which we have to undertake ourselves proactively? In that case, we ask the question, should we become a lawyer or an IT expert or a quality expert or a bank expert? Who knows what's wrong?
I would answer one after the other. Yes, there is an audit which you have to take.
Okay.
Because in the worst case, as I said, there's a step 1 to step 4 analysis. And if you return under step 1, you're fine. Then you can end the analysis right there and don't have to go further than that. But if you find under step 1 that you have an obligation, then you should probably move through the next few steps in order to see which ones are more important. Second, this is a techno-legal process. So you have to get a lawyer on board, because as I said, the kind of language which you're going to have to use in a privacy policy is going to completely change. A lot of companies have this, thing where they pick up privacy policy templates from online and they utilize those in their own existing websites and such like. At least as far as the liability perspective, that's going to be a big danger. You can't do that. You need to be very clear about what kind of data you're using, how you're using it, what conditions you're putting on it, all of that. So, but technologically, there's kind of, that's why I said, you have to change your software code and your code of conduct, both.
And also see, we perfectly understand the concern, right? Because from a commercial perspective, unless you're sort of really required to do something by law, why would you invest the cost, the time?
That is the question. So the argument many B2B companies do is, if let my client anyway audits my process, right?
Yes.
He won't work with it, right? Otherwise. So if they are doing it, on top of it, we are 271 assessed, except for 1 or 2 cases, unless there is specifically called out. For example, data residency is the problem, that they say you shall put this data only there and not outside, which is fine. which is the main concern. The other concern is about laptop. So that data in motion you don't allow beyond the private cloud, which is also fine. But beyond that, are we really supposed to do anything? Is something which nobody, so everybody is doing wait and watch, including the customers.
I understand.
And these are big guys.
Yeah.
So that is what is surprising, right? Because nobody has actually taken anything. I have seen the compliance checklist. There is one checklist available actually.
Sure.
So look at how much of it are you, I mean, it's like a yes, no, red, green, yellow types. But that is about, an inventory check rather than a compliance.
Understood.
You know what the problem is, but you don't know what to do with it.
No, you're right. I think at this stage, a lot of companies trying to figure out exactly how they would be.
Yeah, so I think that's an interesting thing. So in Indian context, outside of the EU, since we don't have yet a policy which states what are my privacy rights, if you may, since that debate is still going on, for the Indian context where the other person, everything is Indian, there is no, we wait and watch, right?
Sure. Yeah.
There is nothing else.
You're saying there's nothing else to do but wait and watch.
Yeah, because if the customer is Indian, the consumers are Indian. Yes, everybody is tracking GDPR.
No, but then you assume that the customers and consumers are Indian. You don't. How?
The same question will come that I may have somebody who's resident in Europe, but Indian citizen, but they run a bank account here, for example, right? Same argument, right?
No, so then we are still required to become. See, this we were talking about.
The only thing is that it covers behavior in the EU of EU residents.
Yeah, exactly.
So behavior of EU residents outside Europe may not be covered.
May not be covered. So we are assuming that when Indian government will propose or release something, maybe driven by this or motivated by this, is when we worry about the pure Indian context. Because it is very unclear, other than only one requirement which we came across, that the data residency should be India. Now they're asking. So previously they didn't never bother. I can put all the bank data somewhere else, nobody bothers. But today, you put it in India.
Yeah. You have to.
That is the only.
So data localization is.
Okay. India. Yeah, it has to be India.
There are specific Indian strategy requirements for data localization in India.
But nothing
and
else
in fact, that requirement doesn't even arise from a data privacy perspective.
Yes,
it's a data security requirement. In fact, more like a data national security requirement.
So it used to be only telco data, IP research, for example.
Yeah. But now I think any financial related data has to be.
So now they're asking you please move down.
So we'll just wind up the webinar. We can continue the discussion.
That's why I wanted you to complete that because this will.
Sorry.
Yeah.
I mean, I thought anybody has any other questions?
Yeah, we'll just close this.
Okay.
Some 30, 40 people.
We had about 100 signs.
Oh, there are more questions. Oh, then
No, I think that's it.
We have the stats, right?
Okay. All right.
Is it Zoom?
Zoom. Oh, there are a couple of last questions. Do we have time?
Okay, we'll go ahead. So if the business is being carried out online through internet without any local presence in any of the EU countries, and there happen to be transactions flowing to the website of a company located in India, would the GDPR be applicable?
Okay, if the business is being carried out online without any local presence in any of the EU countries, and there happen to be transactions flowing to the website of the company in India, would the so the important point here is, so then I assume that there are three, of course, like I said, there are three factors which need to be taken into account for determining if GDPR is applicable broadly. One is there an establishment? From what you say in your question, there is no establishment. 2 and 3 need more information in order to answer that question. Is it the data of local residents, of EU residents, that is flowing through the website located in India? That is, if the business is being carried out online without any local presence and there happens to be transactions flowing to the website of a company located in India, are those transactions flowing from an EU resident? That's the question. Or are those transactions relating to the behavior of an EU resident in the EU? So those are the two distinctions. One is, are those transactions relating to data of an EU resident anywhere? There's no specific requirement. Or are those transactions relating to the behavior or monitoring of behavior of an EU resident in the EU? So that part of information is an important factor if you want to have this question answered. Yeah, happy to discuss in more detail later on.
Yeah,
That
Dagmar,
depends
please
on the-
email us if you'd like more information. We're happy to take questions on email.
Yeah.
One more question. When foreign directors are appointed in companies incorporated in India, what will be the compliance required to be followed by the proposed company, the professionals involved, and the MCA? Extremely interesting. So assume you're talking about if you have an EU resident and national, or not necessarily a national, just an EU resident who is appointed as a director in an Indian company, whether the GDPR would apply. Anyone?
Yeah, I mean, sure. I mean, like, you want to know what the company and the professionals and the
I
MC would need to
think,
be
are you
compliant with.
asking if the GDPR would apply to all of these people?
I'm presuming that's what you want to know.
It's your subsidiary person.
No, but then.
I'm the director of Mrs. India here.
No, I think.
So again, we have to go back to the basics, right?
Yeah.
So are you offering? So if you're not based in the EU,
So here's they're talking about the processing of data in an employee context. A foreign director is effectively an employee and official of the company. So the liability requirement would be the one applicable to employees, which is not the same liability regime as that applicable to data subjects.
fair.
So it would involve some compliance, but is not the same sort of compliance which overruns the whole GDPR as far as data subjects is concerned. The director will be an employee of the company.
Swati, happy to discuss this further in detail. Please email us if you'd like. Okay, you want to conclude?
So thank you everyone for joining us for this webinar, and we hope you found this session useful. If you have any further questions, any follow-on questions, please feel free to write to us.
Yeah, I think our email IDs are all there in the presentation. So.
Yeah. And we'll be happy to get in touch with you and respond.
No, the email IDs are there.
It's there in the end.
Okay, then. So if you need to send us any questions, please go ahead at this ID.
Okay, thank you very much.
Thank you. Okay, there we are. Okay.
So the other thing I was just thinking, see,
You
the weight and watch.
remember I put the GDPR topic on CM.
Long back,
That we
yeah.
should discuss this rather than other things.
Oh,
You know, we can discuss angel tax, that's fine.
Mm.
We went to the meeting anyway, but this is more important because it fits everybody.
No,
It does.
this
That's exactly what we discussed.
session.